ready?
Yes, sir.
Proceed.
Judge, we'd ask that we have initially filed a motion for consecutive sentencing alleging a 4035-115B4. The defendant is a dangerous offender whose behavior indicates no regard for human life and no hesitation about committing a crime when the risk to human life is high. We filed a notice of enhancement factors, both provided previously to defense, noting that the defendant is a range 1 offender, citing that he possessed or employed a firearm or other deadly weapon during the course of the commission of the offenses, and that he again has no hesitation about committing a crime when the risk to human life is high. We'd ask that a copy of the pre-sentence be marked, the report be marked as the first exhibit to the hearing, Your Honor.
Mr. Massey or Mr. Fuss, do you have any comments?
Your Honor, I think we wanted to address that after we'd addressed all the other sentencing factors, but if you want us to address that, we can address it right now. I can make short swift of the enhancements. Number 9 is what they've checked. The defendant possessed or employed a firearm, explosive device, or other deadly weapon during the commission of the offense. Well, that's part of the convicted offenses, Your Honor. It's number 10, the defendant had no hesitation about committing a crime when the risk to human life was high. Your Honor, there's no proof of that. We went completely through this trial, and there was never proof that this young man would act without hesitation when he knew the risk of danger to life was high. What the jury told us is he didn't intend to shoot anyone, so he can't possibly intend to quickly cause harm to people without considering them. This was a one-time incident. For more than 20 years, this young man was not in trouble. Every single day that passed from the time he was born to the time that morning happened tells us he acted, his life wasn't full of no hesitation toward human life. His life was just the opposite. We have no history of him acting without disregard to the other humans around him. There's simply no proof of that. There's no pattern of conduct that even suggests that about this young man.
All right. Is there any objection to the pre-sentence report being marked as an exhibit?
No, Your Honor.
All right, mark Exhibit A to this hearing, the pre-sentence report. Okay. All right, you gonna have any proof?
Your Honor, we have some written statements, which I guess we'll pass forward at the end. We have a number of witnesses. The third and fourth witness that we will be calling, Ms. Lang and Ms. Tate, are juvenile, so we'd ask the court to instruct the media not to record them during their testimony, and I'll revisit that later on. Our first witness will be Ms. Vivian Woods.
Okay.
What's the name again?
Vivian Woods.
Thank you.
Ms. Woods, if you would please step forward. Stand up and raise your right hand, please.
You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
Have a seat.
She does it somewhere.
Good afternoon, Ms. Woods.
Good afternoon.
And you are Vivian Woods.
Yes, Vivian Woodstainer.
And would you tell the ladies and gentlemen what your relationship was to Martoiya Lang?
I am the mother of Martoiya Lang.
And Ms. Taylor, you want to call Ms. Taylor, Ms. Woods?
Either way.
Okay. Going back that period of time, what I'm going to be talking about or asking you about is what effect this has had on your life, both emotionally, physically, financially, basically the impact it's had on your life under what we call victim impact. You're allowed to talk about that now, unlike during the trial. What type of a person daughter was Martoiya.
So I need to speak first, or can I read the letter?
If you'd like to read your letter, you are certainly welcome to read it, ma'am.
I'd rather read it. Martoiya was my daughter, woman of God, sister, aunt, fiancée, and mother of 4 beautiful daughters, whom she dearly loved. Her enthusiasm for life was beyond measure. A contagious smile that was infectious toward everyone she met. Martoiya was the epitome of life itself. Martoiya loved her job. She was a member of a proud team of police officers, Team 6, who executed their duties willingly and without fear. She was a valued member of the team, and I'm sure her team members were proud to have served with her. Martoiya's life was tragically taken by the irresponsible actions of youth Treveno Campbell. The day her life ended, December 14, 2012, has been the longest and saddest day of my life. She honored her oath, the honor to protect and serve the citizens of Memphis, Tennessee. I feel the agony and pain of losing her, as if it was this morning and every morning. I will always remember every detail of that dreadful morning because of you, Treveno Campbell. A statement was made that you, Treveno Campbell, made a basic error. I want you to know this day, basic error. Don't take people's lives. Basic errors don't kill our loved ones, taking them from their families. Basic errors don't take what you can't give back. You will always be a murderer and a cop killer, infecting and infesting our community with the poison that you sell for profit, instead of obtaining an honest day of living. It was murder, plain and simple. The recurring thoughts of what Martoiya must have felt when your bullet entered her precious body. It's what I imagine happening to me each time it comes to my mind. I often wonder what were her last thoughts, her last words. What did she want to say to us? What were her feelings? Did she suffer? Was she at peace with leaving us? These questions will forever be embedded in my mind. The initial shock, the unacceptance of the event that have played in my mind over and over again. Martoiya's death will always be a replay in our lives that will never pause or end. It seems impossible that anyone could endure such pain. I cry tears of pain and anger to the depth of my soul. It hurts bad. Martoiya should be here to endure her family, to nurture her children and give them guidance, and her undying love that she had for them. My regrets are that she will never see her children graduate from high school, college, attend events, proms, debutante balls, etc., become adults, start careers. Most of all, she will never get the chance to see her baby girl attend first day of school. Jory has drawn pictures of her mother and family every day since this tragic event, conveying how she misses her mother, wants to be with her mother, and asks, when is she coming home? Treveno Campbell, your coward and selfish act of violence has filled our lives with chaos and torment beyond repair. Martoiya loved her family, and her family loved her. I miss her smile, her voice, her compassion, her love and zest for life. I miss praying with her every morning before she went to work. We're still trying to find ways to get through it, to understand it, to deal with it, to accept that we must live with it. Nearly 5 years later, we are still at odds with how to come to terms with such a cruel and violent act of senselessness. Treveno Campbell, you have shown no remorse, and you have no remorse. I am personally appalled and insulted by your blatant disregard for the laws. I pray and will continuously pray with every fiber of my being and every breath that I take that you, Treveno Campbell, will always remember killing Martoiya, taking her from her family and children without consciousness of sympathy or regret. For every tear that I've shed and will shed, I pray that your life is as painful as ours. I pray that you are given the same consideration and judgment that you gave Martoiya, which was none. Even if you spend the rest of your life incarcerated, you still breathe the air and have the support and love of your family. I firmly believe if you live by the sword, you should die by the sword.
Judge, I'd ask to be marked the next exhibit to this hearing.
Sorry.
I'd ask that be marked as an exhibit to this hearing, next exhibit.
Okay. Do you have any questions?
No questions, Your Honor, but if she read that into the record, I'm not sure why the document should go in. I don't know if there's any precedent for
Part
that.
of the record, but there's an objection. I think it's already in the record.
I'm just doing it for appellate purposes, but I guess it's
All right, I'll mark it. Mark exhibit D.
It should be.
All right, I'm going to call you next witness.
The next witness, Judge, is Miss Lawana Ivory.
Savvy? Mr. Secretary, please, ma'am. Mr. Secretary, please your right hand.
Solemnly swear the testimony you're about to give is the truth, whole truth, nothing but the truth.
Miss Ivory, will you spell your first and last name for the court reporter, please, ma'am?
Yes, my first name is Lawana, L-A-W-A-N-A. Last name is Ivory, I-V-O-R-Y.
I'm going to pass forward to you the statement that you prepared. And I think you wanted to read that and you wanted to tell us some other things as well. Tell us how you knew Martoiya.
Martoiya was my best friend. I met her in 2000. We were deputy jailers together, so that's how I met, and we've been close ever since.
And would you like now to read the letter that you prepared as a victim impact statement?
Before I do,
Yes, ma'am.
I just like to say one thing. It's kind of hard to feel like, I'm tired of feeling like I'm wrong for mourning my friend as if she wasn't the victim. The world we live in today seems to honor the bad. I'm just wanting justice for her girls, and I think that that's what's important here. They're treating her as if she's not the victim, and she is. I'll go ahead and read from my letter. It started off, good morning, it's afternoon now, but good morning, Your Honor. My name is Lawana Ivory. I'm standing before you today on behalf of my best friend, slain MPD officer Martoiya Lang. On December 14, 2012, I received devastating news from Martoiya's mother to meet her at the med as soon as possible because Martoiya was shot. Upon arriving, I learned that she did not survive her injuries. All I can remember is being on the floor crying and my friend helping me up. Words really can't describe the pain that I've endured since Martoiya was murdered. Martoiya was an outstanding police officer, a great mother, sister, and the true definition of a friend. I must admit it is difficult not having her around. Holidays are not the same. There are no more road trips with the kids, no shopping adventures, private jokes, and her teasing me about my superb driving skills. Most of all, I'll miss our sisterly bond and our talks about life. Even today, I still mourn the tragic loss of my sister and best friend. It deeply saddens me to think of the void her daughters are left to deal with, and it's simply not fair. I keep hearing talk that the defendant did not receive a fair trial. The evidence was presented to the court, and the jury rendered a verdict of guilty of murder in the second degree. For every choice we make carries a consequence, and in this case, his choice is deserving of the maximum penalty for the crime he committed. With his decision, he has changed the lives of 4 beautiful girls who will never have their mother around for graduations, proms, weddings, birth of grandchildren, or just a simple phone call. Nothing and no one can ever give that back or take her place. And that's the end of my statement.
And may we mark that as the next exhibit to the hearing?
Mark Exhibit C, statement from Ms. Ivory.
Is there anything else that we haven't asked you and that you haven't said that you think the judge at this point should hear?
I just want justice for my friend. I want her to rest in peace.
Thank you, ma'am.
Thank you.
We'll call your next witness.
Our next witness, judge, is Ms. Martoiya Lang. Again, she's a juvenile, so I'd ask Your Honor to instruct the media to turn off all the cameras and recording devices.
Yes, sir, could you do that, please?
Martoiya Lang. Martoiya Lang.
RITNEYMARZETTE.
And how did you know Martoiya?
She is my sister.
And did you prepare a letter as well?
Yes, ma'am.
Did you want to read your letter, or did you have something you wanted to tell the judge before you read your letter?
Kind of both.
I'm sorry?
Both.
Okay.
If I could read it first.
You can read it first, yes, ma'am.
Dear Judge, my name is Brittany and I'm the youngest sister of late Officer Lang. Since her death, our family has literally fallen apart. We barely have family functions. We don't communicate as much. And when Toya's name is mentioned, we break down and cry. Every single day we are reminded that the rock of our family is no longer here with us. When you look into her daughter's eyes, you see pain. My heart hurts for them every day. I really can't express how I feel in writing these words, but I will try my best. Toya was more than a big sister to me. She was my best friend, my role model, my mother figure. We had a bond like no other. When I got the news about what happened, my heart sank. Seeing her lifeless in the emergency room damaged my soul, and touching her body, feeling the temperature get colder and colder killed me. I suffer from anxiety and depression now because of this. I barely sleep. I'm sometimes unable to function. I cry every single day because she's not here with us. Ultimately, I know God has a plan for everything, and I wish we all knew what that reason was. But for now, all we can do is continue to pray for strength and justice for my sister. And in addition to that, people really don't know what it feels like to see someone you love on the hospital bed with a tube down their throat, and they're sitting there lifeless. And I literally felt her head cold, her shoulders cold, and her body warm, and her temperature is leaving. It's like her soul is slowly leaving. And you're sitting there talking to her saying, "You got time, come back, because you're in shock." I never thought I would ever get a call like that. But every morning, me and my mom, we would talk on the phone and pray, because she's a police officer and they do dangerous work, but that nobody will ever understand what our family has gone through, what we're still going through years later. It's like a missing puzzle piece. I can't put it in words. And for Treveno, I'm upset at the situation. I am mad about it, but he made his bed and he has to lay in it. I wish it were different. I wish she was still here, but that's not the case. He still gets to talk to his family. Phone calls, he can see them.
He's still breathing. He can do everything that she can't do right now. And my nieces are left without a mother. My youngest niece, all of them are hurting, but my youngest niece, she still remembers that day. She was the last person to see her. And for her to only have memories, and she sits there and she draws pictures of her mom in the grave and everybody visiting her. And then on the next picture, she'll have another picture of her in heaven. So that's really hard on me to see my nieces going through that and being raised without a mother. So I don't show any mercy towards Treveno, but ultimately God has a say so on where his soul is going to lie. But you have broken up a family. You have done that.
We mark her letter, you got judges, the next exhibit to the hearing.
I think you're going to need a statement from this,
Okay. Portia Woods.
You solemnly swear the testimony you're about to give is the truth, whole truth, nothing but the truth. Say, please.
Good afternoon. Would you state your name and spell your first and last name, please?
My name is Martoiya Woods. It's spelled Marquachauntia. Last name Woods, Woods.
And Ms. Woods, what was your relationship to Martoiya Lang?
I'm her sister.
And would you like to tell the judge how the loss of Officer Lang has affected you and your family?
Toya was an amazing person. She was, I think if anyone ever knew or met her, she would be like your best friend. And I had her with me my entire life. So when I got that call that morning that she had been shot, I was at work. And so I didn't answer my phone because I was busy. So my dad ended up getting in touch with my aunt, and she called me at work. And he was like, well, Toya's been shot. I never thought that it would be, she's not coming home. I was like, well, okay, maybe she just got shot in the leg or something. So I hurried up. I got to the hospital. And even once I was there, I never, ever would dream that she would be coming home. So when I found out she wasn't with us, when I saw her in the room, it took something from me. Like I haven't been the same and I will never be the same. I feel like it took the life out of me. And not only have I seen that come from me, I've seen it in my sister, my nieces, my dad, my mom, our entire family, her friends, her team. It's just something missing that will never be there. And that day will never be the same. And I've watched the home where I was with my dad grow with my nieces and watch them grow. It's not the same because no one can raise them like their mother. I'm their aunt. I do my best, but I'm not their mother. No one can replace that. I see my mom trying to go every day, and my dad like everything's okay, but they aren't. At that same time that she was murdered, like we had another family crisis, and I needed her more than I've needed anyone in my life, and she wasn't there. But we talked, and she was going to be there. I mean, those were the plans that we made. And I feel like I needed her support then, and I know she would have been there, and she wasn't. Because she was taken from me by Mr. Campbell. And, I mean, she was supposed to be my chemo buddy. I didn't have her there because she was taken. And now I have issues sleeping at night. My nieces do. My niece Darren, her room is right across the hall from me. There are nights and days that it may be quiet 2 or 3 in the morning, and you'll hear someone just break out in tears. Oh, well, that's because we're hurting. We're not healed. We never will be. And so it hurts me more seeing my nieces and my mom, my dad, my sisters hurt, because I hold a lot in. But it hurts seeing them and seeing Zaria grow up. Sometimes, like you heard, she writes the pictures, but there are days that she'll turn around and she'll just go get in the corner and cry because she wants her mom. I see that. I've seen that the last 5 years, and I have to tell her it's nothing she did wrong for her mom not to be here. That it wasn't her fault. It wasn't any of our fault that her mom didn't come home. But it's only so much that you can explain to a 6-year-old. And at that time, 3, 4, and 5, and even now. Because I don't want her to grow up with hate. I mean, just hate in her heart. I don't. And the financial burden, that aspect is nothing, because we're family. We're going to stay together. But it's just her daughters, them going to college. Her oldest is in college now. She missed that. The second one's getting ready to go. Zaria's first day of school. Those were things she would be there for. Their weddings that may one day come. And it's nothing that they can do or say, but Treveno and his family haven't shown any kind of empathy. And I try to put myself in anyone's position. And I think that if the roles were reversed and I was on his side, I couldn't be that person that, well, it's not right. I would have to listen to the facts, and I would be empathetic and not saying walk on eggshells, but understand these people are going through something that I'm happy I'm not. But I couldn't imagine. I have to go to a grave and see her. It's so surreal that sometimes I just wait for my phone to ring knowing it's her, or to share a joke with her that she's not here. The last words I said to my sister the day before she got killed was that I love you. Sister, those were our last words, because I would always tell her I love you, and she would tell me she loves me. And it hurts because we're not healing. We're damaged. We'll be damaged forever. I've become more of a shell of a person. I don't go out like I used to. I don't deal with people as much as I used to from losing her, because I have trust issues due to that. I trust no one. I see what the world can do, and it's not pretty. I think that he deserves the maximum sentence and time that he can get. It will be justice for her. Maybe her daughters can feel safe that he may not be home tomorrow or the next year. And I mean, it's nothing that we can do to bring her back, but she deserves justice.
Judge, we have letters from Marvin Wood, Martoiya's father, who has been here during this entire thing, and Mr. Campbell, who also wrote letters and asked that they be marked as exhibits to the hearing. I've provided the different copies of those letters. I don't have anything. You haven't given me anything. I don't know what he's got.
Exhibit F, letter from Mr. Malone. Mark Exhibit G, a letter from Marvin Wood. Next witness.
Yes, the next witness will be William Roman. Before I call him, I'd like to point out to the court that Daryl Dodson, Eric Dobbins, and Lewis Mobley are also present in the courtroom. We've chosen to have Officer Roman testify. I would also point out to the court that the remaining members of Team 6 have been here today. But many of them had to go back to work. But I think I can submit to the court that they all ask Your Honor for the maximum punishment in this matter. I'll call Officer Prisoner at this point.
All right, you solemnly swear the testimony you're about to give is the truth, whole truth, nothing but the truth.
I swear.
Please spell your first and last name for the court reporter, please.
First name William, William. Last name Vroman, V as in Victor, Rooman.
And you were shot during this, is that correct?
Yes, ma'am.
Okay. Can you tell the judge a little bit about how your injury and what happened has impacted your life? Has
Yes, ma'am.
impacted Team 6? And how the death of Martoiya Lang has impacted you and the other members of Team 6? And a little bit about what you feel the punishment should be in this matter.
Going back to, I've sat and thought many nights of what I would say, and different emotions have run through me, and it seems like all that's lost right now. December 14th, 2012, as I lay on a sidewalk porch bleeding out, I have to make phone calls to my family telling them that I can't come to my son's birthday party because I don't know if I'm going to live or die. This is before I knew that my partner had been shot and killed. I didn't find that out until I was getting the clothes stripped off of me in the trauma room, that a doctor had enough courage to tell me that my friend had succumbed to her injuries. So there is the initial physical injuries that I will have with me as a constant reminder every day that this man did this to me. Those injuries healed. I went home. I wasn't able to hold my children. I wasn't able to go home and tell my son that night, happy birthday, I love you. I got to sit in the med. Physical injuries heal, but the mental, the emotional scars that I will have on my heart will last my entire life. I will never forget this. I will never be the same man that I was prior to December 14th, 2012. And I've seen so much on social media that men in blue, women in blue are cowards. We are men, we're women, we're brothers, we're sisters, we're sons, we're daughters. We are people that will stand up and do for this city that nobody else cares to do. And I know the men and women that were with me in that house that day, they are men and women of character. Martoiya Lang was a woman of character. She was the hardest working woman I had ever had the pleasure of working with. Words cannot express how torn I am since December 14th, 2012. I like to consider myself a strong man. I like to consider my teammates strong men and women of character, godly men and women that are doing this for the right reasons. We're not out here covering anything up. We're out here doing our job. We want to go home. We want to love on our loved ones. We want to kiss our little boys good night, happy birthday. The things I've seen and heard and said to me when we were going through this trial originally, all of this resurfaced. And I hear my little daughter and my son, Daddy, be careful, the bad man that shot you, or your partner's going to be with you. The fear that they have to get for their daddy. Nobody else could care two cents for me, but my children love me, and they want to see me come home. Just like that family over there wanted to see their mother, their daughter, their sister, their aunt. They wanted to see her come home. She won't. I know I've had countless hours with my friends, with my partners, my brothers. I've had countless hours sitting up at night talking like, how do you get over something this traumatic in your life? And the answer is you don't. Whenever the Lord does call me home, I will take this. I will have this every night of my life. My kids will have this every night of my life. When I put on this uniform and I go out and I do God's work, I'm here to protect everybody that's out there. And I know those men and women are too. Wondering, will my time come? Will I meet my Maker for doing what God has called me to do? That's something that I'll always have to take with me, the emotional scores. And I'm sorry, ma'am, your other question.
What do you think the punishment should be in this matter?
I will have to live the rest of my life with this. My partners will have to live the rest of their life with this. And never forget, I have physical injuries on my body and I have emotional scars on my heart. I will never be the same man. So the fullest extent of the law, whatever that punishment is what I feel should be the punishment.
Thank you.
All right.
That's the state's proof in this matter.
Your Massey or Ms. McCluskey?
Can I call Treveno Campbell, please?
Treveno. Raise your right hand.
You solemnly swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
Yes, sir.
You have a seat,
State your name, please.
Treveno Campbell.
And you are Treveno's mother, is that correct?
I am Treveno Campbell's mother.
Tell us, please, what type of young man Treveno was.
Treveno.
Young man.
Okay, Treveno is my second child. He's my only son. And words cannot express how I feel right now. Treveno is a loving person. Unfortunately, he was introduced to this, and this is something that came to Treveno. But I'm finna tell you right now, he's not a cop killer, he's not a murderer. And whoever can say that they have animosity, I understand, because I don't know what went on December the 14th. I'm sorry for the Lang family, for what happened. My heart go out to her kids, her family, her mother. But Treveno is a human, and he's a person as well. And my son is not a killer. Whoever the killer is in this room, I'm just gonna say one thing. I pray that God will reveal whatever took place on that day. If Treveno did this, it was unknowing. If Treveno did this, it was unknown, because Treveno lost a father as well as a child. And he's not a killer. And he has a heart big as gold. He will give the clothes off his back. I love him. Treveno, I stand for him every day. And I'm so sorry for the Lang family that they don't have Montoya today. My heart bleeds for the family because we are God-fearing people, and we know that we can't answer to no one but God. That's who we answer to. And I mean, it's just sad.
Ms. Campbell, was Treveno the kind that did what you told him?
He did what I told him.
He obeyed rules that you made?
He obeyed rules. Treveno was very gentle.
And what about school? How was he in school? Did he enjoy school?
He enjoyed school. For all who don't know, Treveno was attending Southwest because he wanted to be a fireman. So he was going to do the EMT class to become a fireman. He wanted to already be EMT certified. It's crushing because now his life is ending to this. But yeah, he wanted to be a fireman. He's very, very smart. He's outgoing. He's quiet, kind of, but he's outgoing.
So he enjoyed learning, he enjoyed school?
He enjoyed school. He has Treveno was very smart. He was shy, but he's smart.
Read many of the letters that came in described him as thoughtful and kind and respectful. Is that what you saw in him as a son as well?
Treveno was very kind. He's very thoughtful. He does anything for anyone, even in jail. Mom, I need to do this. I mean, he's just that person. He's not a killer. I'm sorry, he's not.
Is he a worker? Is he a hard worker?
He's a hard worker. Like I said, he wanted to become a fireman. He loves trying to be a business person, accounting and things. But yes, Treveno is very hard worker.
Did he work during high school?
He did. He ran Debo's. He worked at Debo's. Yeah, Debo's Hot Wings. He worked there while he was in school.
And then after he got out of school, he
continued working. He went to school. He continued to go to school. He was a hard worker. He's laid back. Treveno's kind of laid back, but he's not going to miss work.
Where was he working at the time of this accident?
He was working at Federal Express.
And how long had he been there?
He'd been there about 2 years.
And did he seem to enjoy his work there?
Yeah, they said I said, where Treveno? They said, like, he at work, he don't call in. But, he was a hard worker.
Is Treveno Campbell the type of young man that this community needs to be afraid of as far as committing any future crimes?
Never. It's a nightmare for Treveno as well. Treveno don't get sleep. I don't get sleep because the picture that they're painting of Treveno, unfortunately, is totally wrong. He is a loving brother, uncle, son, grandson. He's a human, and he's very loving. He was a loving student, a loving employer, and I'm sure he's a loving client to you. He has a heart big as gold. I'm telling you, he has a heart big as gold.
Since this happened, and Treveno's been locked up, has he been remorseful? Sorry this happened.
Treveno, I don't really think Treveno even remember what really happened.
No,
but he's very remorseful. He's sorry. Look at him right now. No one in here can look. I mean, look at him. He's standing strong and sitting strong because of the strength that God has given him. He don't have strength. He's not a killer. I'm sorry. Yes, he's very remorseful.
Do you think that he's the type man who learns from any mistakes he may make and has the potential to be rehabilitated to make up for those mistakes?
I pray. It's a life lesson for everyone, and I know it's a life lesson for Treveno. He don't want me to worry about him, but I worry about him. And I pray, and I know that this is a lesson. I mean, he's a human, he's not an animal. Only animals don't have conscience. Treveno has a conscience.
Let me ask you this. Did you ever have to discipline Treveno ever? If you had to send him to his room or give him a whop?
I mean, I'm a disciplined type person, you know. Treveno wasn't the child that needed a lot of discipline. I get on to him. He liked to step and play the game all the time. I got on to him, but not really. Treveno, like I said, he's very mild, obedient, respectful.
Thank you. No other questions. Statement here.
Mr. Toog or Toog, is that your brother?
Mr. Tug,
Yeah.
that's my brother-in-law.
That's your brother-in-law?
It is.
And you said that Treveno does what you told him to do, is that right?
He does.
Did you tell him to sell drugs out of that house with your brother-in-law?
I don't know that Treveno sold drugs.
Did you know that your brother-in-law was selling drugs?
We're talking about Treveno. I don't know that Treveno sold
I'm
drugs.
asking you about your brother-in-law.
I have no idea.
And did you know that Mr. Campbell, your son, was living with a gangster's disciple?
He's not a gangster disciple. My little brother, my brother-in-law, he's not a gangster
Is there
disciple.
any proof of that anywhere? I've never seen it or heard of it till council brings it up now.
It's in the search
I
warrant,
think
Judge.
it's a valid question to be asked. I mean, there's a basis for asking the question, obviously, so there was no proof introduced in the trial, but there was basis for asking that question, so I'll overrule your objection.
Well, Tug is my nephew. Well, my brother. I married his brother. I've been with him ever since he was in the 2nd grade. I don't know anything of a gangster disciple. I have no idea of that.
But you thought it was okay for your son to be living with him?
My son was grown. He didn't live there. He went there a lot, but he's grown. I don't know what go on. My son is respectful to me, so whatever went on, it's out of my knowing.
No further questions, Your Honor.
Anything else, Mr. Maxwell?
No other questions.
You can call your next witness.
Dion Wooten, please.
You solemnly swear the testimony you're about to give is the truth, whole truth, nothing but the truth. You have a seat.
Please state your name, please, and spell it for the court reporter.
Dion Wooten, DIONNEWOOTEN.
And Ms. Wooten, are you a relation to Mr. Campbell?
I'm a very good friend of his mother, Treveno Campbell.
And how long have you known Treveno?
About 15 years.
And would you tell the court what type of person Treveno Campbell is?
Treveno Campbell is a very quiet young man, hardworking, very good heart person.
How did he act with others? Was he considerate to others or rude to others? Or
Never at all. He very seldom talked. He's a very quiet young man, nice. I always tell Trina how sweet he is.
was he helpful to his mother?
Was he helpful?
Mm-hmm.
Yeah, he's very helpful. Yep, he talks about her, and he loved his mom. And matter of fact, on December 14th, we were supposed to go celebrate Trina's birthday when all of this happened. His mother's birthday.
Tell the court what you know about Treveno Campbell's work history.
His work history, I know that he worked at Debo's Hot Wings and Federal Express. And he was going to school to be a fireman. Those were his dreams.
So he was working while he was going to school?
Correct.
Any criminal record that you know of?
Not at all. Not at all. I looked at Treveno Campbell as my own son.
Hard-working, going to school, no prior record?
Not at all.
had a gun when being fired.
Correct.
Do you think that Treveno Campbell is the type of person that presents a danger to the community in the future?
Not at all.
Do you think that he is the type of person that learns from mistakes and makes them right?
Yes.
Particularly rehabilitated?
Correct. Yes, sir.
And lastly, how has this affected Treveno and his family?
Well, I can tell you this, that they are a praying family. Everybody's praying every day over this whole situation. It's horrible for both sides. You know, it's just horrible.
I forgot to ask you a moment ago. Would you consider Treveno Campbell to be a respectful person?
Very respectful. Yes, ma'am. No, sir. Very respectful.
Did you ever know him to get in trouble in school when the teachers were having to call his mom? Or?
No one ever called Trina at all. He's a smart young man. Thank you.
Remember, called Jeffrey Franklin.
So help me God.
Mr. Franklin, would you state your first and last name for the court?
First name is Jeffrey, Jeffrey. Last name is Franklin, Franklin.
Mr. Franklin, what is your occupation?
My occupation, I'm in retail management with Sam's Club, and I'm also assistant pastor at Christ in You Faith Temple.
Christ
in You Faith Temple, pastored by Tommy L. Brown Jr.
Christ in You Faith and Temple. Now, how do you know Mr. Campbell?
Well, I know Mr. Campbell, Treveno, from pastoral visits, coming to see him throughout the duration of this dilemma. I've gotten to know the young man over a course of 4 to 5 years. Very outstanding young man. From talking with him, the Treveno I heard portrayed over this microphone, I hadn't met him. I'm just going to be honest with you.
Before this event took place, you had not met Mr.
No, I'm talking about that character that was portrayed, you know, the heinous murderer and with malicious intent. I hadn't met that young man. Well, the young man I've met is somebody who has aspirations to better his community. A threat? No. I've lived around killers. I've lived around gangsters. And I know what a gangster and a killer look like and what they sound like. I know individuals that wouldn't hesitate to shoot at a police officer. No harm, you know, directed to you. I have much respect for the authorities, okay? But the demeanor I get from this young man is somebody that actually want to be an activist for the community. You know, it's unfortunate that sometimes young black men, they have some things against them, you know, not to play a race card or anything, but sometimes it's rough for a young black man when he's trying to achieve things in life.
I don't think you're playing a race card. I think you're trying to be real with us. You live in a community that's mostly made up of persons of what color?
Well,
as far as the neighborhood, the house you live in, the church you go to, are they people from the Orient?
The actual community I live in is a diverse community. You may find some Asians, you may find some Africans, you may find some whites, you're going to find some blacks. Everybody minds their own business. They take care of their business. Everybody in my community works. The church, the community where I worship, now there's crime all around that place. And that is prime prime real estate for a spiritual reconditioning. Now, what I would tell you from dealing with individuals that I've seen sell dope or even, you know, have that demeanor to be a threat to the community, they don't have no concern for anybody's life. You know, I know people that will not hesitate to do what they need to do. Speaking to Treveno, just being honest, sometimes I pray, sometimes he pray. We talk about the word of God. We talk about this situation. All I've seen is strength from this young man. All I've seen is confidence from that young man. Confidence in God. Maybe not confidence so much in the justice system, but confidence in God. And I'm just keeping it 100.
Now let me ask you this. How long have you known Mr. Campbell?
4 to 5 years, man.
And during that time, you talked about demeanor of persons that were, you would know in the community, persons who would be mean and harmful to others. Mr. Campbell, did he ever exhibit a demeanor to you that would show you that he would be somebody who's probably just slinging a little dope on the side, getting involved in a little gang activity? Was there something about him ever that let you know, yeah, this is a guy who slings dope and will get involved in any old thing the gang's doing? Did you ever see any of that demeanor from Treveno Campbell? Ma'am, I hadn't saw anything that even looked like a gangster in Treveno. I'm just going to be honest, because that's a lifestyle I once portrayed for myself. And like I said, I grew up around that element. I grew up in that element. So I know what a killer what a killer looks like. I know what his demeanor is. You know what I'm saying? No respect for life whatsoever. I'm gonna tell you what I got from Treveno. I got an humble young man. I got a young man that, you know what, this is a bad situation. Anybody can see that this is a bad situation. My heart and my prayers go out to the Lang family. They lost somebody dearly. Everybody in this courtroom is hurting in some kind of way. Nobody but God can heal this pain. But I'm going to tell you one thing. If justice has not been served like it's supposed to, if the truth has not went forth, then I pray God reveal that truth. You see what I'm saying? Why should a cop plead the fifth? You understand what I'm saying? Well, let's talk for a
Go
second.
ahead.
I really want you to concentrate to help the judge understand who Treveno Campbell is.
Yes, ma'am.
I'm not interested in explaining to the judge anybody else in the universe.
Yes, ma'am.
But I do want him very much to know about Mr. Campbell.
Yes, ma'am.
Now, have you ever pastored anyone else that's been incarcerated?
Yes, ma'am. I've come to see various individuals. My pastor's nephew had spent some time in 201 Poplar.
And 201 Poplar, can it cause people to get a little snarly, shall we say, and a little mean, and a little attitude going on?
Ma'am, I'm going to be honest with you. Sometimes even coming to pay a traffic ticket, and I respect the officers, but sometimes
I meant the inmates. I'm talking about the inmates.
Okay, all right.
Inmates.
All right,
You're
the
dealing
inmates.
with people. Does it have a negative effect on the people you've seen being incarcerated?
Honestly, it can have a negative effect
Did
if you allow
it have a
it.
negative effect on Mr. Campbell, or did he seem to keep his head above the fray?
Treveno kept his composure. I never come in a day and visited Treveno where he was distraught, where he was about to break down and lose his mind. You know, every time I come in, it's the same demeanor, the whole process. I'm going to be honest, I never seen a person under so much pressure also be under so much peace.
Now,
I never seen that.
When you would come to see Mr. Campbell, did you ever have an officer say, well, you know, we're going to have to wait on that because he's in the hole because he's been in trouble? Were you ever told that this young man had caused a ruckus?
No, ma'am, never.
You never had to wait on him because he was in the hole or anything like that?
No, ma'am.
Never had to have special guards bring him down because he was a danger?
Not one time.
Remorsefulness. Did it appear to you in your conversations with him that he was truly sorry that this officer had died and that everything happened today?
Yes, ma'am, because once again, a bad situation. And from talking to Treveno, I knew he understood the parameters of the situation. And for somebody to lose a family member the way the Lang family did, yeah, I mean, your heart goes out to him. I'm just being honest. It don't matter.
Did it appear that his heart went out, that he
Yes,
had
ma'am.
sympathy for the children and the family?
Yes, ma'am. Treveno is a very concerned person, okay? And as I said today, threat to the community, no.
I want to talk to you about that. When you talk to him, could he see a future? Like, was there at a time when you would talk about, well, what would your future be like? Or when when this situation has passed over you,
Mhm.
did he show you a forward-thinking young man?
Yes,
Or did
ma'am.
he seem like he was a man who was wrapped up in anger and vengefulness? Or did he see a different, happier, normal future for himself?
Ma'am, I didn't see a hint of anger. I don't even know what Treveno looked like angry, to be honest. His mama probably seen him angry more than I have. What I've heard from talking with Treveno and what I gathered from that young man is somebody that's spending time reading and preparing his mind for the day of his release. You understand what I'm
Did
saying?
he strike you as a person who, once part of society again, would be a respectful member of society?
Yes, ma'am.
Did he strike you as a person who would be a responsible member of society?
Yes, ma'am.
Did he strike you as a person who would be anything but a danger to society?
Ma'am, I don't see danger at all. I don't see no reason to be alarmed at all.
And did he appear, when you would see him, of course he's surrounded by officers, was he respectful to those officers?
Ma'am, Treveno's always been respectful, excuse me. I have seen nothing but respect from
And
this
when
young
you
man.
saw him interact with the officers that he was there with, he was respectful?
He always carried himself the way his mom taught him. And that's be respectful to everyone.
No further questions.
Just a few questions. Now, Mr. Franklin, I'm gathering from your testimony, you believe him to be a good young man, Mr. Campbell, is that correct?
Yes, sir, that's very correct.
And you have visited him numerous times since he's been here, 201 Poplar, the past 4 or 5 years, whatever, correct?
Yes, sir.
Did you ever go to where he lived on Mendenhall Cove?
No, sir, I never visited his home.
Okay. And did you ever visit him or know him before he was incarcerated?
No, sir.
So you don't really know what his life was or what he was doing before he was here at 201 Poplar, do you?
No, sir, and that's really not my concern.
It may not be your concern, but that was my question.
Yes, sir.
You
I
don't
understand.
know anything about his life, what was going on in that house or anything like that?
No, sir.
Because you never knew him before he was here at 201 Poplar, is that correct?
No, sir.
That's all I have.
Thank you, sir. Next statement. Call your next witness.
John, please, in Portland City, we've got a courtroom full of people. Treveno Campbell, a lot of people here on his behalf. You would hear a lot of the very same things you've already heard over and over. I would like to read the names off the people that are here for him.
Okay.
There's Martoiya Campbell and Kenneth Erai, Patricia Morris, Sierra Bird, Michelle Brown, Dion Wooten, Jeffrey Franklin, Stephanie Love, Mary Hines, Priscilla Bryant, Manosia Sanders, Mary Morrell, Gary Smith, Benita White, Marcus Randolph, LaShara Green, Marisha Jennings, Tyron Davis, Tony Hurd, Davius Collins, Domiga Williams, Melanie Holloman, Zacharias Swift, Willie Braddock, Larry Johnson, Teresa Scarlock, Latasha Churchman, Quita Churchman, Latanya Churchman, and Mark Carlos Jordan. They would likewise, Your Honor, have similar accolades for Treveno Campbell.
All right.
Your Honor, in addition, we have character letters I would like to pass forward to the court.
Judge, we haven't seen any of those. They haven't been provided.
Turner, I would ask that those letters be moved to Gavin's place.
You good?
Judge, we've read them as
All
quickly
right,
as we
mark
can.
Exhibit H, collective, 6 letters from Ellen Kershaw, Stephanie Hawkins, Philistine Carey, Latoya Mitchell, Jamacetta Wilkins, and another Stephanie Hawkins. I've read all of the letters, marking as Exhibit H, collective.
Your Honor, I would also pass to the court a letter, a statement, Treveno Campbell.
Dated just a few minutes ago, I think, Judge, at least today.
Okay.
It's dated today, Your Honor, but not just a few minutes ago.
Okay. Mark Exhibit I, a statement or a letter from Mr. Campbell.
That's, we've already, we have no further witnesses, Your Honor. Okay, Ellen.
Sure.
Your Honor, Mr. Campbell wishes to allocute briefly.
Okay.
I just wanted to say I'm sorry. I ain't intending for none of this go on. I know y'all probably won't accept my apology. I ain't intending for none of this go on. I ain't this bad person. You know, tell my family I appreciate y'all supporting me and sorry for y'all too. This tragedy, this is a nightmare for me too, man. That's all just want to let y'all know. So I just seeing our kids get up there and talk. Man, it break me down too, man. I'm going to do it, man. I'm just sorry for this, man. I ain't had no intentions on doing nothing. I didn't know what was going on. This is a nightmare, man.
Thank you, no further questions.
Okay, any other arguments or comments?
Because obviously, you were there for the entire trial, so I'm not going to argue facts. I know the court takes copious notes. I'm sure the court has reviewed all those notes and the evidence, so I won't go over that. But regarding today's testimony and what's been filed by the state, I certainly would ask the court to take into consideration for the sentencing what we have as enhancement factors in this, and that this was a firearm that was used to kill a police officer. Not going further into the facts, I will say that from the state's position, the remorse that Mr. Campbell has shown is the remorse that he has shown today. The pre-sentence report is certainly one of the things that was marked. I would direct your attention to the portion that says on, I believe it's page 4, defendant's version was defendant provided the following statement orally to the officer during his interview, and I quote, "I'm innocent, caught up in a bad situation, signed and dated Treveno Campbell, 3/14/2017. Obviously a different situation today after we've had the victim impact. Certainly, one thing I would agree, it's definitely a tragedy for everybody, but unfortunately it's more than a tragedy. It's a criminal act in which the jury has convicted Mr. Campbell of second-degree murder, criminal attempt, second-degree murder, reckless endangerment, employing a firearm, 3 counts during the commission of a dangerous felony, as well as the drug charges. And the state's position, consistent with our motion or notice of the enhancement factors, is that the maximum punishment be sought. In this case, I understand, I believe their side about the lack of a prior record, but of course this won't be the first time someone was murdered and the person who didn't have a prior record. But what we have to go by is what happened during the course of that trial, and the verdict of the jury with the court agreed as 13th juror with what the jury returned as being reasonable. And I would ask that the court not only seek the maximum punishment, but also that the court look at running these consecutive. We have more than one victim in this case. This wasn't a one-shot situation, a two-shot. This wasn't a criminal responsibility situation where some other people did some things and he ultimately held responsible for that. This is all Mr. Campbell. And I believe from the proof that we elicited during the trial with regard to how Ms. Lang was shot, the court recalls with those trajectory rods, how this Special Agent Rena Braswell testified, and another issue with regard to how Mr. Broom, who did testify today, was shot, where we indicated that he had to have been in the doorway. There's no way he could have been back up against that wall, because I'm sure remembers all that. There were no bullet holes going through the walls to where Mr. Broom was. So we're talking about separate acts with this weapon that he had loaded there with him. The The court knows about the illegal activity that was going on, all the dope. It just permeated the courtroom. Mr. Treveno Campbell testified on his own behalf, and the court knows how we meticulously went through all of that evidence, everything that was in his room, all the dope, all the nearly $4,000 that he accounted for by saying that he wanted playing video games. Not once during any of that time period when he testified did he mention anything about being remorseful or sorry for the family's loss or anything like that. And so I'd like the court to consider circumstances under which things have been brought forth today as opposed to back then when the trial was going on. But I especially want the court to consider, other than what is dictated by law with regard to the consecutive sentencing on the employment of a firearm under the commission of dangerous felony, the fact that we do have separate victims, separate acts, and at least 11 shots by Mr. Campbell. And at some point, common sense dictates, and the jury certainly did in their verdict, that you have to know what you're doing at some point. Even if you didn't know in the very beginning, you've got to know at some point after all of that, and the movement and the positioning that he had to take when he did those things. He may have been the most wonderful person in the world prior to that, but on December 14, 2012, that wasn't the person that was at that address at Mindanao Cove where Martoiya Lang life was taken, where other officers on Team 6 life was put in danger, and where Mr. Bruman, as he testified, didn't even know whether he was going to be making it home because he was shot as well. And that's the state's position. I can consult with my counsel, That's all, Judge.
Yes, thank you. And I would like to begin with the purpose of sentencing. The foremost purpose of our sentencing law is to promote justice. And I'd like to point out just one of those principles, and that is the first principle, that every defendant shall be punished by the imposition of a sentence justly deserved in relation to the seriousness of the offense. Sentencing is not for retribution. Sentencing is not to get back at someone. Sentencing is not for the state. Sentencing is not for the victims. It is for the defendant to be punished justly with the sentence that he deserves for the seriousness of the crime. The court has considerations it's required to look at under our law. Under 4035-103, confinements necessary to protect society by restraining a defendant with long history of criminal conduct. That's not the criminal. There is no history of criminal conduct. You have a young man, 22 years old, no juvenile court history, no criminal court history. How unique that is for not just this courtroom, but for this building and for the one across the street, the federal building with criminal cases. Unique, indeed. The only crime that he's thus far been convicted of involved people when they burst into his home with a battering ram. It's a dangerous activity, and it's led to the no-knock policy being no longer the go-to policy. And it's because it was dangerous to have that technique. That's not blaming the officers. It's just a recognition of the reality and how certain things undertaken that seemed like a good idea at the time, over time, we realized there are problems with this technique. The situation that he was in is very specific. It's not a situation that you encounter very often at all. So confinement necessary to avoid depreciating the seriousness of the offense, particularly suited to provide effective deterrence to others likely to commit a similar offense. That's a little odd to even try to apply in this situation. Measures less restrictive have been restrictive than confinement have frequently or recently been applied unsuccessfully. No, this gentleman falls outside that consideration. The sentence imposed should be no greater than that deserved for the offense committed. Certainly, Your Honor, on that one, no greater than deserved for a person who was barely awake and very much afraid. The jurors did not believe his action was intentional. Their decision could be respected with the lowest sentence because they didn't believe it was intentional. A sentence that would comport with Section 4, which is a sentence that would be imposed, which should be the least severe measure necessary to achieve the purpose for which this sentence is imposed, would certainly, again, be a sentence at the lowest end of the considerations by this court. In the area that, number 5, I'm sorry, there's no indication, Your Honor, under 5, the potential or lack of potential for the rehabilitation or treatment of the defendant is to be considered. There's nothing out there that shows that there's any lack of potential for this young man to be rehabilitated. In fact, everything we have shows just the opposite. He came up just the way we want our children in this county to come up. They go to school. They have parents who make sure they're in school. They're respectful to the authorities. They graduate from high school. When they graduate from high school, he's still going the old school way. And that's try to, go on to college, move forward like that, even if it's a junior college. He's doing that. Get a job. He had a job. Your Honor, there is an area, I'm not saying it's being considered by this court because I don't think it will be, but it is nonetheless an area that I think is alive in this courtroom today. And that is, Your Honor, social media. A lot of the pain we saw up there, a lot of the jitteriness, a lot of the anger, they would be staring at Mr. Campbell, but the words out of their mouth would be social media, what I've heard, what people are saying. He doesn't have access to social media. He's not posting things online. What we have is this weird universe that we're now in where the internet can reach out and hurt people. Hurt them terribly. People who don't even know Mr. Campbell can get on the internet and promote something saying they're for Mr. Campbell. He doesn't know. He's in the bowels of the building over there. He has no idea this stuff is going on. People he don't know are saying things, promoting things. It hurts these people. Other people jump in, this side of the room gets hurt. Social media has hurt so many people back here, Your Honor. And it's in this courtroom because their pain and their anger shows today. And it's good that we get to hear from them. But we need to recognize when they're angry and they're yelling, their voices get high and they're shaking all over, the words coming out of their mouth are directed toward what other people have said, not Mr. Campbell. I'd like for a moment, Your Honor, to move to mitigation factors. The defendant acted under strong provocation. I don't think provocation is quite the right word for what happened that morning, but certainly the situation created a strong response in him. He wakes up, he's 22 years old, barely awake, and very much afraid. He hears the loud noises. I think it's important to remember that one of the officers testified that although he's with this Team 6 for so very long, and he knows these folks, they do everything together. They go through situations that would just terrify other people, but they're together all the time. They know each other's voices. They know what each other sounds like. They know each other's words. But what did he tell us? He told us that that day he could hear the voices, but he didn't know who the voices were or what they were saying. This is from somebody who's with these guys all the time. What could it be like for the person who wakes up and in the hearing is all the middle of this coming in? So he's got the high heart rate, he's got the adrenaline, he's got everything. The body's just gone into instinct mode. And there was nothing ever presented that disputed his claim that he was asleep when they hit that house. He woke up to this, and he jumped, and he moved. Substantial grounds exist tending to excuse or justify the defendant's criminal conduct, though failing to establish a defense. I think that's just exactly the situation we have now. He hasn't been excused for the conduct. The jury said no to that one. But at sentencing, we can appreciate between what he said happened that has not been disputed and what the jury's told us. That is a mitigating factor. The defendant, because of youth or old age, lacked substantial judgment in committing the offense. He was 22. He'd never been in a situation where all of a sudden there's a loud noise going on and he has to make a decision. He'd never been there before. He's 22. The defendant was motivated by a desire to provide necessities for the defendant's family or the defendant itself. The necessity would be that instinct that hits you when you're afraid to protect yourself. The defendant, although found guilty of the crime, committed the offense under such unusual circumstances that it's unlikely that a sustained intent to violate the law motivated the criminal conduct. Now, I think that's a very important mitigator. This happened quickly. He responded quickly. There's nothing to show that he had any sustained intent to continue to hurt people or act in a criminal fashion. It was over in a matter of seconds, or even, the whole affair, dangerous moments, only lasted, a minute between the time they came in the door and then finally he was shot? Seconds on his part. Seconds that those 11 shots went off. The defendant acted under duress, or even through the duress. It was not sufficient, even though the duress was not sufficient to constitute a defense of the crime. Again, Your Honor, the facts and circumstances that we heard in this courtroom. Chapter number 13 under mitigation allows for any other factor consistent with the purposes of this chapter. Your Honor would submit that one of those would be the attitude in the community toward the defendant. There have been many people in the community who have politely and calmly said that they support him and his efforts, they understand the jury's decision, and he has members of his family and friends that support him. I think the change in the policy toward no-knocks is a mitigating factor. It's something that, quite unfortunately, we've all learned something. A shorter sentence is likely to allow Mr. Campbell to take his place in society as a useful citizen at the earliest time consistent with protecting the public. If he's sentenced to the low end, Your Honor, between the his past history, which is no criminal offenses, and the time he would be in prison, which is significant even at the low end, he can become a useful member of this society. Social and correctional resources of the community match or are suitable to the client's needs. His past, what we all say is the past predicts the future. Well, he has a decent past. We can predict that as soon as he gets out, he will continue with his past behavior and be a good citizen. Conduct of the defendant between the offense date and the sentencing date has been exemplary. No problems at all. We all know how the jail can get. We all know what the jail can do to people. Not once. No write-ups. Not one write-up on this young man. And he's at that fiery little age. He's at the age when they're young, when they come in here at 22, somebody's got to be the tough guy in the cell block. They get into it. You see it all the time. You see co-defendants, they have to be separated, given different dates. They're hot-headed when they're young like that. Not this young man. Not this young man. The defendant has the capacity to adjust to law-abiding behavior. His time that he's been incarcerated showed he can adjust his behavior regardless of the circumstance. Strong possibility of successful education and training while incarcerated. He's clever. He's smart. The sentence that you're going to give him, even the lowest one, puts him in there for a long time. He could have a college degree by the time he came out. So yes, he can make even a sentence of imprisonment benefit all of us. On December
14th of 2012. He was 22 years old, barely awake, yet very much afraid. It's undisputed that he awoke to the door being smashed in. He didn't take time to process it. He processed through that really fast funk, fear, confusion, and he reacted impulsively, without intent. The impulsiveness is shown from the physical evidence. Bullet holes in the odd little places in that room, and the walls, first one wall, then another. The photos, when the officer explained that the first photos that we saw of the casings on the ground, they were just inside that doorway, consistent with fires coming over there near the head of the bed. Had he been out that doorway shooting, he would look like Swiss cheese, because he would have had Officer Lang, the minute he poked his nose out that door, he would have encountered Officer Lang, because the testimony from the forensics doctor was her arms were left like that. So she's coming down the hall like this. He poked his nose out, she's got him. He poked his arm out, she's got him. And guess who's got him on the other side? He's got the officers that are in Braddock's room. Poke his head out, they'll see him, they'll take him out. They have some big ugly guns. Had he been standing in the doorway that the state promoted today? No. This sentencing hearing never would have come about. During the trial, the state had a witness who put him over there by the end of the dresser. Carefully pointed out and went back and said how, yes, the shots were fired. Like he was hiding out, over there, just waiting for somebody to come in. They abandoned that, and they've switched it now to right over here. No. Physical evidence is consistent with it happening as he explained it. He hears the noise, jumps out, grabs his gun, jumps out of bed, basically kind of tumbling out of the bed because he's scrambling to get up. She's firing, goes over there. About that time, the officers came in. The randomness of the bullets, the bullet that struck her left arm, the oddity that it would strike her in the left arm. If she's coming down the hall, if she's coming in the room, it would all been on the right side. Nobody can ever begin to explain how that officer got shot in the left arm. And the oddity of how just that rare moment when her arms just lifted at exactly the spot that would allow the bullet to pass through. All this, Your Honor, goes to show that it was an impulsive reaction based on fear. The state made a point earlier that his expression of sorrow today somehow didn't fit with the pre-sentence report when he said, I'm innocent, it was a bad situation. For a young man who is, well, just so stingy with his words, he hit it perfectly. It's a bad situation. It was a bad situation that day. It's a bad situation for all these people in this courtroom. Mr. Campbell, and the jury agreed, didn't intend to shoot anyone. A minimum sentence is appropriate. The officer testified that if he didn't know he would live or die that day. No, Mr. Campbell didn't know either.
Your Honor, if I may, I will address consecutive sentencing.
Judge?
State seat. I'm sorry, do you have a response?
Yeah, I have a response.
Okay.
Well, go ahead.
Just finish, and then you can say whatever.
Under the state seeks consecutive sentencing based upon him being a dangerous offender. And our courts have noted for a long, long time that is the most subjective and hardest to apply factor of the consecutive sentencing statute. And it's a difficult burden on the state. It takes more than just arguing. It takes proof. And the court also in Wilkerson stated that satisfaction of the dangerous offender section by itself is insufficient. The The trial court must also determine two other things. They must determine whether, number one, the sentences imposed are reasonably related to the severity of the offenses, and number two, are necessary to protect the public from further criminal activity by Mr. Campbell. Well, Your Honor, reasonably related to the severity. With the criminal attempt, second-degree murders on Officer Brewman, we know that shot came through a wall.
No, it didn't.
We know that shot, yes, that shot went through a wall, and he had the dust on his pants. Isn't that the one?
Yeah.
Yes, yes. He had the dust, talked about the dust still being on his pants. Now, that's very different from this stuff from shooting somebody. Shooting through a wall is. At least I submit to the court it is. Secondly, when you look at Officer Dotson, the other criminal attempt, second-degree murder, I don't recall any testimony saying Treveno Campbell shot at him. Treveno Campbell, according to Dotson said he came in, that Treveno still had his gun, and he poured 3 shells at him. Now, I don't know how he gets convicted of second-degree murder, attempted second-degree murder, when he didn't fire a shot at this officer. So I respectfully submit that a low sentence there and a non-consecutive sentence is not needed based on the severity of the offenses, at least factually. Secondly, the sentence must be necessary to protect the public from further criminal acts. I think the court has heard this over and over. He's been described as mild-mannered, non-aggressive, respectful, not loud or pushy, never rude or impolite, positive, mild man, quiet, good, kind-hearted. I don't know how, I mean, to me, I would agree with the preacher. It's, I don't know a dangerous Treveno Campbell. I haven't seen that. Everything about him says just the opposite. And that society does not need to keep him in jail longer to protect him from future criminal activity. So I respectfully submit, Your Honor, that the consecutive sentencing should not be granted other than the statutory for the guns. I know that has to be consecutive. But for the larger offenses, I respectfully submitted that consecutive sentencing is not necessary to promote justice, nor is it necessary to, it's not the least sentence possible to address what has happened. What we're talking about is 15 years as a minimum. And that's hard time, Judge. That's hard time. And this is a young man. And you know, that's not a bad man either. He's not a bad person. He's a young man that's worked when others were out running the streets. He's a man that was going to school when his peers were out doing other things. I respectfully submit, Your Honor, that consecutive sentencing would not be appropriate in this case.
I just wanted to, won't be long, be rather brief, point out a couple of things. We keep hearing about this was not an intentional act pursuant to the jury's verdict. And I'm not sure what act we're talking about. We're talking about the jury's verdict, for instance, for murder second was not premeditated to be murder first. But I think that intent is involved in this when you start talking about a conviction for murder in the second degree. Maybe not premeditation as a first degree, but certainly there is intent involved in that. And so I don't think that's a legitimate argument saying that the jury's verdict indicate that he had, being Mr. Campbell, no intent. We also heard talk about there's no indication of motivation that if he was released early or something, that he wouldn't have any motivation to continue with any type of activity because he didn't have any type of criminal record. I think the court needs to keep in mind the activities that were going on which was selling drugs, which the jury did convict him of that based on the evidence in the case. And certainly, regardless of what else he was doing, whether he was working at FedEx at night or Debo's or wherever he was, the court was certainly here for all the drugs that were in there in his room, the scales, the baggies, all of that. And certainly that's something that could continue, or motivation to continue doing illegal activities. I know nothing about any change in a no-knock policy because they still do that. And with regard to Mr. Campbell being awakened and alerted and not knowing what's going on, he had the ability to get his loaded gun and fire 11 times, whereas Mr. Willie Braddock, who was further down the hall, as the court recalls, when he went in the house, all the way down 2 bedrooms down the hall from him, immediately put his hands up and then was arrested. And then you had people coming back, and Vrooman gets shot. That's not the same situation as somebody tumbling out of bed. And I'll let the court rely on its own memory of what occurred with regard to the proof we elicited through forensics, because there were no holes in the walls where that dresser was, which would indicate where Vrooman was shot. That were none. And I know the court is aware of what that testimony was. I won't belabor the point. But my point about all of this is that these were acts, not a single act falling out of bed and all of a sudden shooting. These are acts of being in one place, being in another place, and continued shooting and shooting at people, which cost the life of Officer Lang. And I think the court remembers when they talked about, one of the officers talked about how they are taught to enter with the slicing the pie and coming around like this, all of that, which explains how she was shot where she was shot. But based on all that testimony and the court's memory and notes of the trial, I think that consecutive sentence would be appropriate in this case.
Your Honor, please, there are statements that were given to you that were made an exhibit for appeal during this trial.
Sorry?
The statements of the officer that pled the fifth. I respectfully, Your Honor has read those and are familiar with those.
Yes, sir, I am.
I would ask you to take those into consideration when you're weighing the severity of the offense as required by Wilkerson.
I'll be more than happy to do that, Mr. Massey. I ruled at the time that Mr. Goodwin's testimony was completely irrelevant, was completely unreliable. There was no basis for it being reliable, and that's why it was not admitted into evidence. So, I read them all. I considered them all. I considered the entire investigation at the time, and I ruled that it had no indicia of reliability, and that's why I wouldn't let it in. And then why he took the fifth is strictly up to him and his lawyer. But the reason it didn't come in because it wasn't reliable. So, I considered it.
That's what I'm looking at.
I think
court is charged with, and I think Ms. McCluskey did a fine job of reading all of the issues, purposes, and sentencing and the considerations, but let me reiterate them again for the record. And the court is charged with considering those. The purposes for sentencing are found in 40-35-102, and the relevant ones to me are that every defendant shall be punished by the imposition of a sentence justly deserved in relation to the seriousness of the offense, that punishment shall be imposed to prevent crime and to promote respect for the law by providing an effective general deterrent to those likely to violate the criminal laws of the state by restraining defendants with a lengthy history of criminal conduct. Sentencing considerations. Court finds are in 40-35-103. Law states that confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. Confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrent to others likely to commit similar offenses, or that measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant, and that the sentence imposed should be no greater than that deserved for the offense committed. The court has considered both the purposes of sentencing and the considerations. The court has reviewed the pre-sentence report that was marked as an exhibit in the case. The court has reviewed the criminal statistics from the administrative office of the court. The court finds, based upon all of the review of the issues involved in the case, that Mr. Campbell is a range 1 standard offender for purposes of sentencing. In going through the sentencing factors for the offense of murder in the second degree as charged in count 1, the court finds that that is a range 1 offender, but is to be served at the rate of 100% release eligibility. The enhancement factors are found in 40-35-114. The court finds in this particular case that one of the elements of murder in the second degree would be inherent, that it would involve a risk of injury to those in the community. Let me see the exact language. The defendant has no hesitation about committing a crime when the risk to human life is high. I think the courts have held that that is an element of murder in the second degree. So obviously the circumstances would make it such, but I think it is an element, so the court cannot consider that, I don't believe. The court does find that the defendant possessed or employed a firearm during the commission of that offense, and I will use that as an enhancement factor, and I will rely on it very heavily. As far as the statutory mitigating factors found in 40-35-114, the defense argues that the defendant acted under strong provocation. I do not find, based upon the proof that I heard in this particular case, that the defendant acted under strong provocation. The provocation that at least I would draw from this is that Mr. Campbell was engaged in selling drugs, that he armed himself with a weapon, and furtherance of selling drugs and protecting either his drugs or his money. And because of that, when from whomever may come into his residence, either to harm him or to steal from him or to take his property, he armed himself, and if I accept all of the arguments that the defense is making, that he acted under the facts, being startled under these circumstances, but I don't find that he acted under strong provocation sufficient for that to be a mitigating factor for sentencing purposes. Substantial grounds exist tending to excuse or justify his conduct. Again, I think Mr. Campbell made certain choices in life, and he lived by those choices, and he exercised his decisions by those choices, and I don't find that they are substantial grounds that would excuse or justify his actions in this case. So I do not find from a statutory standpoint that that is a mitigating factor that's applicable. The defendant, because of his age, lacked substantial judgment in committing this offense. I don't find that that is applicable just based on the testimony I've heard. He finished school, was going to college, was working,
was engaged in activities. I don't find that he lacked the substantial ability to make a judgment about certain circumstances in which he placed himself. Finally, that the defendant, though guilty of the crime, committed the offense under such unusual circumstances that it is unlikely that a substantial or that a sustained intent to violate the law motivated the criminal conduct. I don't find that there's sufficient proof in this case for me to find that as a mitigating factor. I have taken into account all of the character proof. I think there was quite a bit of character proof with regard to Mr. Campbell's character after the fact and the relationships that some of these people had with Mr. Campbell. And I have accepted and listened to that as I do think a valid testimony for purposes of mitigation. With regard to the issues involved in sentencing for this particular case, again, this is a situation in which I have a picture that has been painted of Mr. Campbell as an individual that everybody liked, and that he was a good student, and that he was a good person, and things very positive about him. But yet, nobody really addressed the big picture involved in this particular case, and that is that Mr. Campbell was the leaseholder of a house. That Mr. Campbell, as a resident of that house, based on the testimony, if I recall correctly, Mr. Braddock kind of came and went. Mr. Little Toot, or whatever his name was, the cousin, kind of came and went, but that Mr. Campbell lived there. And during the course of living in that particular house, and this is not a drug-infested neighborhood, this is not some location where all kinds of evil and bad sordid things occur. This was a residential neighborhood in a residential area. It was a quiet little cove, and Mr. Campbell chose to sell drugs. Mr. Campbell chose to sell drugs in that community and in this community that we live in. Nobody seems to want to address that issue from that standpoint. Mr. Campbell made that decision to sell drugs. The proof in this case is overwhelming that he was selling drugs. The proof is there was a lot of drugs in that house. Bagged, packaged, ready for resale, cash. We're not talking about small amounts. We're talking about a lot of stuff inside that residence that give an indication that it is a house used for selling drugs. Mr. Campbell's house, where he lived. Then, because he chose to engage in the sale of drugs in our community, because he chose to choose that lifestyle, he chose to arm himself with a gun to protect his drugs, to protect his money, if you want to say to protect himself from those who would come to steal his drugs or to steal his money. But he chose to arm himself with a gun to protect his drugs to be sold in our community. That's a decision Mr. Campbell made. There's nothing in here that says that because he went to school, because he was going to college, because he had 2 jobs, because he was this good person on the one side, that it justifies A, selling drugs in our community, B, arming yourself with a gun to protect your drugs and your turf. Now, I don't know who Little Toot is. I don't know what Little Toot does. He's somebody's cousin, Mr. Campbell's cousin or uncle. I don't remember now from the proof. I think maybe it was an uncle. And the mom said it was her brother or brother-in-law. I do remember that. So I know that's who the search warrant was for. Search warrant was actually for cocaine. Yeah, they didn't find cocaine, but they sure found a lot of marijuana. And there was the gun that Mr. Campbell had, but there was a lot of ammunition in that house. There was a lot of bullets in that house. A lot. I mean, far more than anything that this court would find as normal in the majority of cases that I've dealt with. There was a lot of ammunition in that house, which has kind of stuck with me and troubled me somewhat when I look at this particular at this particular case. And members of the Memphis Police Department who are charged with protecting Mr. Campbell, protecting his neighbors, protecting our streets, protecting our society, who are doing their job to protect us from drugs and from people that sell drugs and from people that rob drug dealers and from people that steal from drug dealers. Their job is to protect us from all of that. Acting on good, solid, legal information, they went to a judge and said, "Judge, we need a search warrant to search this house. We have reason to believe there are drugs and guns in that house." And a judge said, "I agree with you." And he gave them a valid search warrant, a legal, valid search warrant to allow them to go in to that house to search for drugs and guns. They were doing their job. And they are being castigated, and they have been reprimanded, and they are talked about for doing their job, for doing the very thing that we pick up the telephone and call and say, "I need help, send the police. I need protection, send the police." And these officers did their job, and they went in legally with a valid document signed by a judge that said, "You have the right to go in this house." And they did. And when they went in there, Mr. Campbell reacted in a way that was inappropriate. He started shooting his gun. Whether he looked and saw who was shooting, I think the law even allows that if the state had sought the death penalty, if they found that Mr. Campbell knew he was killing a police officer in the course of their duties, that's an aggravating circumstance that justifies the death penalty. If they believed that he was intentionally trying to kill a police officer in the course of their duties, I don't question the circumstances under which Mr. Campbell found himself. I can't even imagine being in dead sleep and hearing my door broke into and hearing all that commotion come in. I can't relate, and I can't imagine what it would have been like or what it would have sounded like or what kind of reaction. But at least at some point, the reaction has got to be reasonable. And what I have is Mr. Campbell, if I accept everything that the defense argues, Mr. Campbell just randomly starts shooting his gun. Whether it was his roommate who stumbled and knocked down the door when he came in. I mean, it could be anything. Somebody knocked a table over when they're walking around in the dark. He just grabbed a gun and starts shooting. More likely, what I suspect, based on all the proof, is there was a lot of commotion, and with all due respect to defense counsel's argument, based on what I heard and based on the photographs that I saw and based on the size of that residence, when we all went out there and looked at the residence and we looked at the photographs of the residence, it's a very small house. It's not very big at all. It's very small. And those police officers, I don't believe, if they're going to go to the trouble of breaking down the door to go inside this residence, are going to come in quietly. Every indication I have, and 2 or 3 of them indicated for us in front of the jury, what they do and what they say when they enter these residences. And it was quite obvious that they're yelling and screaming, "We're the police, we're the police," whatever, "we have a search warrant," but they're making a whole lot of noise, "We're the police." And Mr. Braddock got down on his hands and held his hands up in the air. And Mr. Campbell started shooting his gun. And the bullets, quite frankly, in my opinion, are consistent with him either shooting from his bed out into the hallway or shooting from the head of his bed at the doorway out into the hallway. And when Officer Lang got shot, I don't know under what circumstances, how he shot her. I don't understand that. But I know that his shots were fired from the head of the bed because they're straight out into the hallway. So he had to either be standing at the head of the bed or sitting in the bed or on the other side of the bed shooting straight out into that hallway. And then at some point he moved over to the side because there were shots fired from the edge of the dresser through the door going into the other direction, going out through that door, going the other way. So he moved, and that's where he was when he was actually apprehended. So I think Mr. Campbell had ample opportunity to react. He had ample opportunity to make decisions. And I don't find that there's any proof in here at all that he was not aware that those were police officers that had entered into his residence. Now, whether he was reacting in a way
or under whatever circumstances, I don't have any idea. But I know that he chose to put that ball rolling when he chose to sell drugs, when he chose to do it in a residential neighborhood, when he chose to get a gun and he chose to use that gun and to keep it loaded and to keep all of those items inside that residence. He's the one that started that ball rolling, and it rolled and it's still rolling, and at some point it's going to stop, and Mr. Campbell has got consequences for his decisions. So I am of the opinion that he possessed and employed a firearm during the commission of the murder of the knowing killing of Officer Lang, and I'm going to put a great deal of emphasis on that factor. I do not find that there are any statutory mitigating factors. I've addressed those other than the character proof, but I think the circumstances under which Mr. Campbell chose to arm himself with a gun during the commission of this particular type of offense outweighs any mitigating factors, and the court is going to impose a sentence of 25 years for murder in the second degree in count 1. Count 2 charges criminal attempt to commit murder in the second degree, involves Officer Vrooman. The court again finds that the inherent in the offense of attempted murder in the second degree is the fact that there would be a risk to human life, so I cannot consider that as a factor in my opinion. Also, I am of the opinion that because he was also convicted of employing a firearm during the commission of this offense, that I should not use the possession or employment of a firearm as an enhancement factor. There's a split of opinion on the Court of Criminal Appeals that some seem to not indicate that it's not. It is inherently something that is not a factor or not an element of attempted murder in the second degree, but because the state chose to indict for that offense, it would appear to me that that would be penalizing Mr. Campbell twice if I were to do that, so I am not going to consider that as an enhancement factor. I do find, again, that there are no statutory mitigating factors, those that I've already addressed, other than the character proof with regard to Mr. Campbell, and I will impose a sentence of 8 years as a range 1 standard offender for that offense. Count 3 charges Mr. Campbell with employing a firearm during the commission of a dangerous felony, that being the attempted murder in the second degree of Officer Vrooman. The court finds that Mr. Campbell is a range 1 standard offender. That sentence, therefore, because of the statute, has to be served at 100%, and it has to be consecutive with the offense that directly preceded it that it refers to. That would be count 2. Again, the court finds as an enhancement factor in this case that the weapon obviously is an element of the offense, so it cannot be an enhancement factor. But I do find that the use of employment of a firearm during the commission of a dangerous felony, there is no hesitation about committing a crime when the risk to human life is high. It is an enhancement factor that I will consider. And in weighing that against the mitigation proof that the court finds as to the character of Mr. Campbell, the court will find that the appropriate sentence for that offense is 6 years. Again, that is a range 1 offender to be served at 100%, and I will impose that sentence for count 3. As to count 4, count 6, and count 8, I will combine all of those for purposes of analyzing. In those cases, those involve the other officers, Dobbins, Goodwin, and Mobley. The jury found the defendant guilty of reckless endangerment, a Class A misdemeanor. The court feels that for purposes of sentencing, again, in looking at the enhancement factors, the employment of a firearm or use of a firearm would be appropriate as a factor to consider. The risk, I think, is an element of reckless endangerment. Again, I have considered the character proof with regard to Mr. Campbell. I will impose a sentence of 11 months and 29 days on each of those 3 counts, 4, 6, and 8. That's to count 10, charging Mr. Campbell with criminal attempt to murder in the second degree. Again, this is involving Officer Dotson. The court finds that he is a range 1 standard offender. The court also finds that there is no enhancement factor that the court can consider. I think an element of the offense is the risk to human life was high,
and also that because the state chose to indict him and he was convicted of employing a firearm during the commission of that offense, I should not consider that as an enhancement factor, therefore I won't. I do find that there are mitigating factors which I have stated with regard to his character, so I will impose a sentence of 8 years as a range 1 standard offender for that offense. Count 11 deals with the employment of a firearm during that offense. The court finds that Mr. Campbell is a range 1 offender. This sentence again has to be served at the rate of 100% per statute. The court finds that there is an enhancement factor, that he had no hesitation about committing a crime when the risk to human life was high by employing and using a firearm. And so I'm going to consider that as a factor. Again, I weighed the mitigating factors. I find no statutory mitigating factors, but I do find that he does have character proof that I have considered. I will impose a sentence of 6 years as a range 1 offender, and that sentence to be served at 100%. Count 12 deals with the unlawful, or strike that, I guess I need that. Because of the way the indictments were pled, I'll go with this. Count 13 involves the unlawful possession of a controlled substance with intent to sell marijuana. The court finds that Mr. Campbell is a range 1 standard offender. In that particular case, the court does find it as an enhancement factor that Mr. Campbell was a leader in the commission of this offense involving 2 or more criminal actors, that Mr. Campbell had no hesitation about committing a crime when the risk to human life was high. That would be, in this court's opinion, the fact that selling drugs in a residential neighborhood creates an aura or an atmosphere around that residence which makes it danger and the risk is high, as obviously indicated by what occurred. And the court will not consider the fact that he employed or used a firearm, because there's another count of the indictment that addresses that. The court also finds there are no statutory mitigating factors other than character proof, which I have considered and weighed, and I will impose a sentence of 1 year as a range 1 standard offender and a $2,000 fine. Count 14 is a charge of unlawful possession of a controlled substance with intent to deliver. This court is of the opinion that that is an alternative to, and the facts would be the same with regard to count 13. Therefore, the court will, although the jury found Mr. Campbell guilty, is going to merge that into the sentence in count 13 for the same reason. I find that he is a range 1 standard offender. I find that he was a leader in the commission of that offense that involved 2 or more criminal actors, and that he had no hesitation about committing that crime when the risk to human life was high. I also find that I will not use or consider the firearm because of the, in count 12, and I have weighed the mitigating factors, and I find that the character proof that's been presented, in weighing those two, the court is of the opinion, even though I am merging them, if there is a question, I will impose a sentence of 1 year as a range 1 standard offender and impose a $2,000 fine. But I am going to merge count 14 into count 13. Count 12 deals with the employment or the possession of a firearm during the commission of offense. The jury found the defendant guilty of possession of a firearm with the intent to go armed during commission of a dangerous offense. The court finds that Mr. Campbell is a range 1 standard offender. This is a D felony, but it has to be served at 100%. Again, the court finds that the defendant had no hesitation about committing a crime when the risk to human life was high. I will consider that factor, and I will also weigh that against the mitigating factor involving Mr. Campbell's character proof, and I will impose a sentence of 3 years as a range 1 offender, but that is to be served at 100%. With regard to consecutive sentencing, obviously this is a case that involves a lot of issues with, that we have already discussed, but again, the court is charged with conducting a determination as to whether or not any or all of these sentences should be served consecutively. The court has asked by the state to consider Mr. Campbell a dangerous offender. The law says that if I am to find that he is a dangerous offender whose behavior indicates little or no regard for human life and that he has no hesitation about committing a crime in which the risk to human life is high, that the court also has to find the following factors: that the circumstances surrounding the commission of the offense are aggravated, that confinement for an extended period of time is necessary to protect society from the defendant's unwillingness to lead a productive life, and the defendant's resort to criminal activity in furtherance of an anti-societal lifestyle, and that the aggregate length of the sentences reasonably relates to the offense of which the defendant stands convicted. Again, in looking at the sentencing considerations, the issue before the court, in my opinion, with regard to imposing consecutive sentencing is whether or not confinement is necessary to avoid depreciating the seriousness of the offense, or is confinement particularly suited to provide an effective deterrent to others likely to commit similar offenses. Obviously, Mr. Campbell does not have a criminal history. Obviously, measures less restrictive than confinement have not been tried because he does not have a criminal history. But that the sentence imposed should be no greater than that deserved for the offense committed. In determining whether or not Mr. Campbell is a dangerous offender, the court again has to find that the circumstances surrounding the commission of the offense are aggravated. I have found, and I do find, that the circumstances in this particular case are aggravated. I find that, again, Mr. Campbell chose to sell drugs in our community. He chose to sell drugs in the community where he lived, which is a small residential cove in East Memphis, backing up to the interstate. When the court took the jury out to that location, and from the testimony and the proof that was presented, it's just a quiet residential neighborhood. There was nothing unique or outstanding about it. It was just a quiet residential neighborhood. And Mr. Campbell chose to sell drugs from that house. And again, there were a lot of drugs. That's something that seems to be being passed over. There were a lot of drugs, and there was a lot of ammunition, which give rise, at least in this court's mind, that there must have been a lot of guns, at least accessible. They weren't in the house, but there sure was a lot of bullets in the house. Live ammunition, a lot of live ammunition. And there was a lot of it in Mr. Campbell's room, in his dresser, not somewhere that was just laying around. It was in his dresser. There was a lot of ammunition in that house. And Mr. Campbell, again, chose to arm himself to protect his drugs and to protect his money and to protect himself from possible, people coming in and stealing his drugs or stealing his money. And so he armed himself. And under those circumstances, again, the police, acting on valid information, got a legal search warrant to do their job to try to control drugs in our community and guns in our community. And acting upon that, they entered this residence, and Mr. Campbell reacted in a way that was just inappropriate. And so I find that the circumstances surrounding this particular offense, it's different from other kinds of homicide. I'm not belittling or changing anybody that's ever been the victim of a homicide or the circumstances. But the circumstances of this, when you view all of the circumstances in totality, why the police were there, the circumstances under which they were there, what was going on inside that residence, and who was behind all of it, it's Mr. Campbell. And so I find that the circumstances surrounding this offense are aggravated. Confinement for an extended period of time is necessary to protect society from this defendant's unwillingness to lead a productive life and the defendant's resort to criminal activity in furtherance of an anti-societal lifestyle. That's the second factor to consider. The aggregate length of the sentences reasonably relates to the offense which the defendant stands convicted is the third factor. This court is of the opinion that confinement for an extended period of time is necessary to protect society from Mr. Campbell's unwillingness to lead a productive life. On the one side, he's leading a productive life. On the other side, he's leading an anti-societal lifestyle, selling drugs, possessing guns in neighborhoods. And this court finds that that factor is present. When you combine that with the aggravated circumstances of the offense, the circumstances that were found, this court does feel that an extended period of time is necessary to protect society from Mr. Campbell's actions and his future or further actions. The aggregate length of the sentence reasonably relates to the offense for which the defendant stands convicted. Again, members of the Memphis Police Department doing their job. There's a lot of things being said and a lot of issues that are out there, and I'm not even going to begin to address those issues. That is not my position, it is not my intention, and it is not my desire to get in the middle of all of that. That is for people to stand on their platforms and say and think and do whatever they choose to do outside of this courtroom. But I will say that in this particular case, I have a group of police officers that were doing their job. They were legally doing their job to try to rid drugs from our community. And in doing that job, one of them was killed, another one was wounded, several of them were put in danger for doing the very thing that we want them to do. And that is, my question is, do you want this in your neighborhood? Do you want Mr. Campbell, who seems like a perfectly nice young man, living next door to you, selling drugs in the house next door to you? Or would you call the police and say, do something about this? Somebody did, and that's why they got a search warrant. So it's the fact that these police officers were there legally doing what they were supposed to do, and one of them lost her life. The other one could have lost his life. Several of them could have lost their life. This court feels that the aggregate length of the sentences reasonably does relate to the offense for which Mr. Campbell stands convicted. I'm going to order that count 1, murder in the second degree, 25 years, be served consecutive to count 2, criminal attempt murder in the second degree, in which I've imposed a sentence of 8 years, consecutive to count 3, which is mandatory by law to be consecutive, in which I impose a sentence of 6 years, and consecutive with count 13, the drug conviction, for 1 year. Those sentences are to be served consecutive. The remainder of the sentences will be served concurrently. And I do feel that the combined length of sentence is appropriate for the circumstances of this offense, the nature of this offense, the aggravated circumstances of this offense. I do find that Mr. Campbell was a dangerous offender and is a dangerous offender, and that it is appropriate that those sentences in particular be served consecutive. So that is my ruling. Now I need to schedule a motion for a new trial date.